So, welcome to our evidence lecture. What? I like laughing too. It's funny. No, I'm just kidding. Okay, so what was I going to say? I'm just going to start laughing. You're going to give me the giggles. This has happened to me in teaching before where I literally can't stop laughing. Is there something on my face? Okay. All right. So, no, it's okay. All right. So, this lecture is evidence. This is probably one of my most favorite approaches and my applicant's most favorite approach, for sure, because evidence is a humongous subject and it really narrows it down to what comes up. So, you definitely want to reference the long outline, but what is within the approach has the California distinctions as well. And I would say is 90% of what comes up on an evidence essay. So you should memorize from this approach, and except for the hearsay exemptions and exceptions, that it does not contain, or the objections. But other than that, we'll go through it, but all of these rules, reliability, character, impeachment, and the privileges, as well as the relevance and public policy considerations, should be memorized from the approach. If you follow this approach and you hit your issues, you will get a very high evidence score if evidence comes up. So there's been a lot of back and forth with students and with just people that talk about this last July 17 exam as to whether or not evidence actually came up. The California bar is a hot mess, and I don't know who's writing the questions. This was a very minor evidentiary essay, meaning one part of evidence came up. So when you read this essay, someone that did not take, so raise your hand if you did not take July 17. Okay, so I only want to hear from Mark or Shauna right now. By the way, we have another Shauna in the house. I never hear my name. Like when you go to Disneyland and there's the cups and the hats, never my name on it. Anyhow, so sad, right? Don't you all feel bad for me now? They just make a custom hat for like $1 million with my name on it. God, Disneyland. Okay, we'll talk about that another time. My thoughts on Mickey and all that. So, reading this, Mark and Shauna, what did you think? I know you didn't issue spot it, but what did you think? Sorry to put you on the spot. The first question, what area of law were they testing in the first question? You thought evidence. Shauna, what did you think? Okay. I think the fact pattern is pretty important, though, so maybe what part, I mean, like a full-blown evidence admissibility approach? Let's read from at trial. At trial against Home Inc., which was now the sole defendant, and by the way, for online students, we will be posting this question tomorrow. At trial against Home Inc., which was now the sole defendant, Claire has attempted to compel Luke to testify. Compel Luke to testify. What area of law is that? What area of law is compel? Civil procedure within the gamuts of what? A motion to compel, right? To testify about what Wendy told him. So is it about the content of the testimony at this point, or is it just that we want Luke to testify? Which one? What? Compelling part. But he has refused, claiming the attorney-client privilege. They're giving you the ground of the objection. They're giving you the ground. She has also attempted to compel him to produce his memorandum, but he has again refused, claiming both the attorney-client privilege and the attorney work product doctrine. What were the two issues that you were to go into for call one? Should the court compel Luke to testify about what Wendy told him? The objection has been made. They said she brought up the attorney-client privilege. and the work product doctrine. Those are your issues. That is it. They're not asking, did the court properly admit the testimony? They're not saying, did the court err in allowing the testimony over prosecutor's objection? That's evidence. So there is an evidence cross here within civil procedure because the work product doctrine is Civ Pro and the attorney-client privilege is evidence. However, attorney-client privilege is also civil procedure. Where is it within civil procedure? Discovery, right? So I have a written complaint into the state bar because this essay to me is civil procedure. Answer according to California law. It is not really an evidence essay. And remember that the state bar fired a lot of people with this whole, if anyone knows the news about them trying to change the standard, and they're trying to change it up, which is why we saw a call with 5 questions, okay? They're trying to make it a little bit different. So they have deviated here. They've never asked something like this, by the way. They've never tricked applicants to this extent. So some applicants were able to see, okay, there's a motion to compel, and there are 2 grounds by which they are objecting to this testimony to come in. The question is not about the relevancy of the testimony. Does everybody see that? It's very important that you see that. And some people didn't even bring up attorney-client privilege or work product doctrine. It's right there. So if they're giving you the grounds by which they're objecting to something coming in, those are the grounds that you're discussing. As attorneys, are you going to bring in superfluous information? So you want someone to testify. The other side is objecting based on 2 grounds, right? They're objecting based on its work product, right? Privileged information and attorney-client privilege. Are you going to bring in, oh wait, what about relevancy? No. You're only going to object or answer to those 2 main grounds being brought up. Does everyone understand that? They gave you the issues. So a lot of people did go off on an evidentiary analysis. How do you know if it's evidence? It's evidence, a straightforward approach like this, where you have to go through this entire potential checklist at what's at issue. It's going to say something along the call is going to say, did the court properly admit the testimony? It's going to put it on the court. Did the court, or should the court, allow or allow the objection to the testimony? Something along those lines. So it's important that you're able to distinguish that. So I am going to say, yes, evidence did come up, and it was a very minor, it was one part of evidence, and it was only the attorney-client privilege. That was the only issue that they wanted you to discuss here. 2 issues, attorney-client privilege regarding call 1, along with work product. And for call 2, A and B, attorney-client privilege and work product as well, repeated for both. Tricky. I would conclude that most applicants, even those that did end up passing, did not do well on this essay. Very tricky calls, right? Right? Super tricky. But I'm going to tell you that from now on, when you can't just rely on the calls, you got to look at the facts as well. The facts are giving you the main objections. So if you got stuck, see the bigger picture. What is happening here procedurally? Take a step back. I'm the attorney on this case. Okay. So in terms of predictions, is evidence due to come up? I'm going to call evidence my wild card, meaning it's fair game, but it's not a high predicted area. And I'll get into the predictions after this approach. Okay. So this is a checklist. Memorization is key within evidence. It's probably one of the hardest areas to memorize because of the character and impeachment rules. So you've got to sit with it. You can make a chart. We've given you a really good amount of support for evidence within your materials. You have not only the long outline, but we also give a hearsay separate outline and a supplement for character and a supplement for impeachment and charts and great mnemonics to really break it down. But again, the focus for the essay portion should be the approach. I mean, you could memorize the approach and do pretty well as long as you also cross-reference the hearsay stuff, okay? So what's in red is what should be discussed always. Always should be discussed. So you can just start with admissibility of witnesses' testimony, let's say. Give a little intro. How do you know if you're supposed to go into California evidence? It will say, answer according to California law. No, it's not printed in red. If you want it in red, we can email it to you. Oh yeah, right up here. But we do have an outline in red, and a lot of people like it because the California distinctions are in red. So if you want that, you can let us know, and Richard will email it to you. Okay? So make sure you make an intro as to whether you have the California Evidence Code at issue or the Federal Rules of Evidence. Page 364, Volume 1. Here we are taking the evidence through a series of hurdles. While the evidence may not be admissible as character evidence, for instance, it may still be admissible as impeachment. Most of the California Evidence Code is similar, if not identical, to the federal rules. If there is no difference, assume the law is the same for both the CEC and the FRE. The admissibility of the name of the evidence is dependent on and go into, obviously, only what they're asking for. If they don't say answer according to California law, it defaults to federal. Federal Rules of Evidence. Logical relevance is your next heading, and you are always to have a heading logical relevance. Do not make one heading relevance. There are two types of relevance, and just go into logical first. This applies to every item of evidence. If you're in item 2, do not say see above for logical relevance. It's a different item of evidence. Clear on that? Now, the first time you go into relevance for the first item of evidence, if evidence comes up on your bar, give your full-blown relevance rules. What do you do for any subsequent admissibility items? Short form, meaning will you always keep your headings? Yes, but you're just going to skip what part of the IRAC? The R, but you still will have your analysis conclusion. Don't get messy, okay? Don't start letting the approach fall apart. Keep your headings. In the essay that got tested on question 2, you had to go into work product and attorney-client privilege several times. Short form would have really helped there. So, meaning no repetition of rules. That's all that means. But we keep our headings, right? Good. So always discuss logical relevance. What is logical relevance? Page 364. Logically relevant evidence is evidence that makes the existence of any material fact of an action more probable than it would be without the evidence. I've given you the setup of your analysis. You can say here the evidence is logically relevant because. Thus the evidence is relevant or irrelevant. Exam tip. The basic question to ask regarding logical relevance is, what proposition is the evidence being used to prove? Is this a material issue in the case? Is the evidence probative of that proposition? Make sure that you understand what probative value is. I see the analysis for logical relevance a lot of times is incorrect, and you have to make sure that you really understand when something would be more probable than not. Any questions so far? So are we always going to have a heading logical relevance? Yes, always. How much time are we going to spend here? Well, if the evidence is highly irrelevant, if the testimony is highly irrelevant, it's a major issue. If it's clearly relevant, establish the logical relevance of it and move out. Not major. Clear? Good. You're always going to have a next heading legal relevance. The trial judge has broad discretion to exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Only go into what you have here. So if you've spotted that, usually always talk about the unfair prejudice part. That's usually what they're looking for. But it's very clear if it's something that would mislead a jury. That's another hot part of the standard. Or undue delay. Only talk about what you have at issue. I've given you the setup here. The evidence is more or less probative than prejudicial because. So do a good job with the balancing test here. Hit it home. This is a work of art. It takes practice to write for both of these concepts. So through your evidence practice, make sure you're making some good weaving in of that key standard, okay? Why is it more or less prejudicial than probative? And back it up. Don't be conclusory here. All right? Okay. You may have a wrinkle in a California criminal case of Proposition 8. So this kind of veers off. This would be, what you would do here is you'd make a heading legal relevance, and then right under it, you make a subheading Proposition 8. And it's basically a mirror of the general federal rule for legal relevance. It's on page 365. In California, the Truth and Evidence Amendment to the California Constitution, Prop 8, makes all relevant evidence in a criminal case admissible, even if it's objectionable under the California Evidence Code, right? But then it's still going to allow it in if they have, they will allow it in, but if they can still exclude it if there's unfair prejudice, which substantially outweighs its probative value. So it's the same standard, right? But just make sure, if you're in a California criminal case, always discuss Prop 8. Always. Not civil, criminal. Okay, so we're always going to go into these headings, right? And then in your mind, you're going to say, do I have any public policy considerations? That's a subgroup within legal relevance. They're just subheadings under it. You don't need to, state that it's part of legal relevance, okay? You still go into this rule always. So what are they? And they cluster. So in blue, I didn't do the blue of the other ones. I'm so patriotic tonight. Okay. Everybody thinks there's always hearsay. Is there always hearsay? No. So your next consideration is any one of these. Now, it'll be very clear and you'll be able to identify any one of these. You'll see a car accident maybe, and one party will say, oh, I'm so sorry, I didn't mean to hit you, I'll pay for, your bills, or proof of insurance, right? Or let's settle this. So it'll be very, very clear. These are easy to identify. Be careful, don't miss them, but that's why it has to be within your checklist, right? So you're stopping in this approach wherever something is at issue. You're always discussing both parts of relevance initially, and then you're saying, okay, do I have any one of these? And this should be memorized, obviously the rules and distinctions as well, within your checklist. Offers to pay medical expenses, subsequent remedial measures, and they're all tested of equal weight and measure. Liability insurance, settlement offers, withdrawing of a guilty plea is not tested as much, although it has come up. And expressions of sympathy in California only. That's California only. And this is all within the approach, as well as the distinctions. If we take a look at page 366, you can see throughout the issues on the bullet points, you see where it says California only, meaning that is your California distinction. Know these rules, memorize them. If you have questions on them, you can individually email me, all right, as you're going through it. I'm not going to read rules. I don't do that. But it is important that you have these down verbatim. You cannot, So there's two ways that you pass an evidence essay. You have to hit your issues, and you have to hit proper rules. Your analysis is usually not as lengthy. So evidence tends to be racehorse, meaning you could have, what's the most admissibility standards you've had in an essay that you've seen? 4. So meaning 4 separate items of evidence. I've seen a little bit more than that. I've seen up to 6 where they veer off in like subparts, right? Like one part of the testimony and then the second part. But let's just say you have 4 items. Each item will have a minimum of, let's say, 5 to 6 issues, right? Or more. Let's highball it and say 6. 6 times 4 is 24. 24 issues. Let's say you've issue spotted for 6-7 minutes. Maybe 8. That leaves you how long to write? 52 minutes. 52 divided by 24 is what? Let's do it. Let's do it. I'm trusting you, but I'm just... What? I'm not a skeptic. I trust him. He's super good at math, not me. What did I say? 52 divided by 24? You're right. You're on the money, right? That's not fair. 2.1. Literally. Which means you got to be watching that clock like stink on you know what. You got to be on the ball with your timing. You'll never see, hardly ever, major counter arguments within evidence. You'll never see major long analysis within evidence. Even if something is on the fence, maybe within hearsay exception. So where can you potentially have your counter arguments here? Just as an overview. Within relevance? Yeah, definitely. If something, maybe it's not 100% prejudicial, right? But it's kind of on the fence. We do see you have to really go through both sides. Yeah. So you could have a major issue here. Here it's usually pretty straightforward as to why it's probative. Okay? Here usually you'll get quickly in and out. Quickly. You're not going to have time. Here is very quickly in and out. You're just establishing what the reliability standard is. Not really going to give any counters here. Character, impeachment, privilege, and hearsay is an area you could have some counter arguments. As we saw in this last question too, July 17, the attorney-client privilege was pretty meaty, but remember, that's a deviation off the general evidence questions. That's the first time they've ever labeled a question like this evidence. We've never seen this before. Okay? All right, so let's continue. So any one of these will be at issue. Now, offers to pay medical expenses, liability insurance, and settlement offers, they all 3 will be at issue at the same time. Meaning if one is at issue, it's likely be on the lookout for the other 2. They cluster. So they tend to be tested together. Offers to pay medical expenses, liability insurance, and settlement offers. They are typically tested together, meaning within the same item of evidence. Okay, so this is maybe. In blue is maybe in your mind, right? Stopping if it's at issue. What is the purpose of an evidence essay? What's the purpose of evidence? Huh? I heard something, no? Say something, Matt? Whether the evidence can come in, right? So, or whether the court properly admitted the evidence, or whether the evidence can be properly objected to, right? So, when you're in trial, and by the way, when we're talking about, remember at the last contracts class, I kind of made a little chart about the different areas of law, right? Where does evidence fit into all this? Everywhere. The California Evidence Code, if you're in state court here, federal rules of evidence, if you're in a trial in federal court. And what you're doing is you are trying to argue for any possible way for the item to come in. Why we have to always discuss certain items is because certain is because for evidence to come in, there are certain legal standards that must always be met. Meaning, if an item is not relevant, there is no way for it to come in. It has to be relevant. Usually you'll find some relevancy, unless it's really prejudicial, then they'll kick it out. They're not going to care about, oh, but Your Honor, there's an exception to hearsay here, even though it might be hearsay as well. It's not relevant, it's prejudicial, it's not coming in. We can authenticate it, maybe they'll hear it. Here, this is maybe at issue. This is only when you have this specific type of evidence. You have somebody saying, let's settle, or I'll pay your medical expenses. That's only when you have specific types of evidence. Now, this is a huge one, and it's probably the most missed issue. Reliability. If you cannot establish the reliability of your evidence at trial, it is not coming in. So if there is a lay witness who's testifying as to what he or she heard or saw, and you establish that he or she actually didn't see or hear what they are testifying to, you are done with your essay. And they have done this. So be careful. You have to establish, in my example, that a lay witness that is tested, there was a fact pattern where there was a bar fight, and the witness wanted to testify as to what happened during the fight. But the facts told you that the witness was not there during the time of the fight. Can the witness now testify as to what happened? No. Meaning you establish that they're a lay witness and there's no personal knowledge, and you're done with this item of evidence. So if you cannot establish reliability, you are done. If you're not sure, you can maybe see if something else applies and discuss it, but you're going to be wasting some time. So this is where proper issue spotting comes in. 9 out of 10 times, you will pass the reliability checkpoint. But there are instances, so if you're on an essay and you're like, wait, I have a lay witness and they weren't there, I'm telling you right now, establish that there's no reliability and move on to your next item, okay? Usually it will not be the first item of evidence. It will be like some of the last ones. Okay? So what do we have? What are our different reliability standards? We have a lay witness needs personal knowledge. We have 2 separate standards. We have Kelly Fry v. Daubert. Make sure you know the differences between each. For written evidence, it needs to be authenticated. So by the way, you're only talking about the reliability standard that pertains to your item of evidence. So if it's a voice, right, what do you need? Authentication. But if you're testifying as to how somebody sounds on a particular time, it's 2. It's personal knowledge, and it's also voice authentication. You have 2 separate authentication hurdles to talk about there. So you could have more than one reliability standard. Please discuss the reliability of the evidence for every item of evidence. Even if you think, oh, yeah, there's personal knowledge, it's clear, duh, that happens a lot, and then you just skip it because you think it's so clear, you're going to lose points. So back to my 4 items, 5 to 6 issues, 24 issues. It's a lot, right? It's a lot. And by the way, I'm kind of lowballing it. You could have more. You could have 2 items could have 4 to 6 hearsay exceptions. That's only the hearsay exceptions. You still have talked about relevance. You still have talked about reliability. Maybe there's a privilege in there, right? So practice makes perfect here. Practice watching that clock, and we'll go into timing at the end. I'll tell you what to do. Okay, what else could you have? You have the best evidence rule in California. We've abolished that, and it's now known as secondary evidence. Don't identify. I was at a trial. I told you I had a trial right before this course. And the attorney said, objection, best evidence rule. And the other attorney goes, oh, that was abolished in California. And I was like, I didn't say it, but my co-counsel did. My dad. was like, Dad, how do you not know that? Love you, Dad. He doesn't watch this, but he's so smart. But when you're older attorneys, you're like, you think you know it all. Gotta stay on top of the law. Okay, character evidence, maybe. It will be very clear if character evidence is at issue. Why? What kind of facts are we looking at? Whose character is at issue? Defendant or victim, right? Plaintiff. So you have to know your criminal character rules. You have to know your civil character rules. I've given you literally what comes up here on an essay within character. In the long outline, I definitely would cross-reference the long outline just to make sure you're very thorough, but you could get by just memorizing this for the essay portion. So this is something you need to sit with. This is something you need to make a chart for, potentially, meaning like civil versus criminal character, and really understand the differences and have it. They're not very complex, but you got to absorb it. You got to memorize it. You can do this, obviously, as you're closer to your memorization. But they all come up equally. So you'll only discuss what applies. You could have character in a civil case. Generally, it's an inadmissible to prove conduct in a civil case. One exception exists under the federal rules. What is that? Sexual assault or child molestation. In such a case, defendant's prior acts of sexual assault or child molestation are admissible to prove defendant's conduct in the case. Pure memorization, but you got to know it. Character and criminal. Two major issues here are the character evidence admissible to prove conduct of the defendant or the victim. Remember, there are separate doors to the admissibility to such evidence. Both are closed when the prosecution begins its case. Only the defendant can open these doors, and usually they are opened separately. We go into admissibility standard to prove the conduct of the defendant and of the victim. Make sure you know the California distinctions here. Again, you can map it out in a piece of paper. I would do a little chart. Turn the page. So I've given you, this is your checklist. So when you notice that there's character evidence, you're seeing a witness testify as to the defendant's prior sexual activity, right? Think about what is going to go on if Harvey Weinstein is actually ever on the stand. Or actually ever being prosecuted. I actually was hoping persecuted. Sorry, I'm just kidding. Just kidding. He's a great guy. No comment. Okay. I don't really wish he should die, but what he did was pretty shitty. I think politics aside, we can all at least agree to that, right? Okay. All right, not getting into it. So anyhow, if you know what I do in my practice, it's a big part of it is sexual harassment, so I deal with it a lot. And crazy what's going on. I mean, all the cases coming out. But I think within everything, we all just need to, one thing I'll say is there are a lot of good guys out there, right? Just so we all know. I think the guys are getting a lot of... Okay, no one wants to talk about this. Anyhow. You're like, God, it's been like over the news so much. Nobody wants to hear about it anymore. But think about the questions that would be asked, okay? And the objections that would be made based on the character rules, right? So they would want to bring up any settlement that happened, right? He doesn't have any, I don't think they actually ever convicted him of anything, convictions or misdemeanors or anything related to past sexual harassment. And so you have to know these rules. And I think when you're memorizing these rules, the best thing is to put this into context. That's the best thing. So try and make up a case in your mind and picture the defendant or the witness on the stand and really ask the questions out loud. I mean, that's how I memorized it. So that would be very helpful. Okay, so you have the rape shield statutes. Those are not tested a lot, but we do have the mimic rules. Those are highly tested in the area of character evidence. On page 370, specific acts of misconduct. Evidence of other crimes or misconduct is admissible if these acts are relevant to some issue other than the defendant's character. So if you label something as character evidence and it's inadmissible, then always look to see if it can come in under this issue, okay? And what that is any other issue other than the defendant's character to commit the crime charged. Such crimes may be admissible to show motive, intent, mistake, or accident. Identity, that's a big one. Common plan or scheme. This is highly tested in the area of character evidence. So make sure you know the mimic rules. Now, if it's not character, is it impeachment? So that's why it's also in blue. The categories that come up here on the essay portion are prior inconsistent statements, prior inconsistent statements of a witness now testifying at trial, impeachment with prior felony conviction. I'm just reading from page 371. Impeachment with prior misdemeanor conviction. Page 372. Non-conviction misconduct bearing on truthfulness. All these are equally tested. So regarding impeachment, these are the main 4 areas that come up on the essay portion. Okay, so let's all look up, and from the beginning, am I wide enough to block this? Okay, what's our first standard? What's our first step? Don't look. Logical relevance, then always discuss. Okay, next. Do I have a public policy consideration? Give me them. What are they? Just say them out loud. Expressions of sympathy, withdrawing guilty pleas. Okay, now where do I go? Shh, now where do I go? Help me. Where do I go next? Reliability, always discuss. Okay, what are my different reliability standards? Personal knowledge of a lay witness, next. Expert witness, good. How many different standards do I have there? Good. Kelly Fry Dauber. Which one's federal? Good. Which one's California? Kelly Fry. Only go into the one that they're asking about, the area of law. What other types of reliability could I have? Authentication of a document. So under federal, you'll have, we want the original, right? What is that? The best evidence rule in California, that's called secondary evidence. We also can have questions about the authentication of a voice, right? You want the authentication to be by someone who's heard the voice, who knows the person, right? They did have a full essay on that once. Okay, where do you go from here? Do I have character? Always discuss? No, only if you have character evidence. If you do, put it down. You're looking for character. Put yourself in context if you're in a civil versus criminal matter, right? And if you do have character or not, look to see if it cannot come if it's inadmissible character, if it could come in one of the mimic forms, okay, specific acts of conduct. Next, where do you go? Impeachment. What are some of the impeachment issues that come up? Prior inconsistent statements. What else? Right, prior misdemeanors, prior felonies. Non-conviction misconduct regarding truthfulness, right? That's a hot one too. They're all equally tested. So even if it's character or not, is it impeachment? Next you go to, is it privileged? Is it privileged? What are the main privilege issues? This just came up. Okay, so this is the hot one, marital communication. We have a testimonial and a confidential standard, right? Separate headings for both. The attorney-client privilege, which was just tested. Doctor-patient. Those are the 3 main ones. There are some other ones that you should take a look at, but these are the 3 main ones that come up. And then look how much we've checklist to get to hearsay. How many essays do you think I see where hearsay is the first heading? Many, right? You're not always going to have hearsay. Could you be done here? Well, could you be done here? Okay. Could you be done here? Could you be done here? Could you be done here? And you could be done here too, right? So you have to be able to identify hearsay. We all know the rule. Being able to identify it is not easy for most. If you need examples of hearsay, if you don't really know what it is, please come see me, email me, I'll send you some examples, okay? You should know how to identify hearsay. Now, I've given you in this approach on page 374 the most tested exemptions. Make sure, this is a pretty meaty area of the outline. If you go to page, just put your thing there and go to page 345. This is your hearsay supplement. This should come in right now in the approach. So this is the next part. You need to memorize this entire thing. Everything here is important. So it goes through the exemptions and the exceptions. Your flashcards can come in handy here to test on the different ones. But this is a thorough list all the way till page 356 on top. We've put it in a chart format. We thought that was easier. And then we have character block and impeachment blocks, meaning condensed versions of the rules as well there. So you can memorize from here for character and impeachment. I just recommend using it as a cross-reference and memorizing from the approach for those areas. Okay? So you need to know all of these different rules regarding non-hearsay and the exceptions. They all get tested in equal weight. Now, when you have hearsay, if you really do, you want to be on the lookout for at least 3 to 4 exceptions. At least 3 to 4 exceptions will be at issue. If you only hit one, you probably haven't issue spotted enough. So doing practice here is key. I'm going to outline how you deal with double hearsay. I didn't do that yet. Okay. Memorization is very important. So if you have double hearsay, go back to your approach on page 374. Identify it as multiple or double hearsay. At issue are multiple levels of hearsay. In order for the entire item of evidence to be admissible, each level of hearsay must fit under a hearsay exception. You need to go into each level individually. So identify the first level. Let's just say you have a police report. And then hit any exceptions separately. Separate IRACs for each. You only need one, okay? Go to the next level. Hold on, let me just finish this and then I'll take questions. Second level. Let's just say the bystander statement within the report. And find any levels here and then exceptions here, and then conclude as to whether or not the entire item will come in. So both levels need to have an exception. Both levels, or else the entire item is inadmissible. Couple things, and then I'll take questions. Some other questions that they like to ask is regarding objections. If they ask for, like a question, for instance, what objections, if any, could the prosecutor have made to this testimony, let's say, or a certain witness testimony, you bring up every possible objection you can, but you do not need to go into any of this. Only the objections. Everyone understand that? So if they're asking for objections, you only go into the objections that can be given. Now, relevance may be an objection, right? So even though we have, asked and answered, or the general objections, attorney-client privilege could be an objection, right? Any evidentiary standard really could be an objection. Authenticity, reliability, personal knowledge, lack of personal knowledge can be an objection. So still take it through that checklist, but use it more in terms of an objection to the evidence. Two other issues that could come up on evidence are judicial notice. They haven't asked for that in a while, but they used to. That is typically done before trial, where you are asking the court, it's an actual motion, and you're asking the court to take judicial notice, let's say, of the contract, because we want it on record that the contract is what the parties are alleging it to be, the actual contract between the parties. There's no dispute about the evidence. The judge is going to take judicial notice of the contract, and on the record, basically, at time of trial, put forward the standard that there's to be no objection to the authenticity of that contract. It is admissible evidence. It typically can, but as a trial attorney, I'm telling you, it's usually done before. It's usually actually done as early as the demur stage. That's usually when it happens. But you definitely can, like there's a period of time before you have your final trial conference where you can bring in a motion for judicial notice. No, the parties don't. No, that's summary judgment. You're thinking about something else, maybe. No, this is one party usually bringing it up and saying, I don't want to have an issue with the other side saying that this contract is not authentic. This is the contract we signed. A lot of times the other side is on the boat, is on, what is the word I'm looking for? Is in agreement with you that, yes, we should just get this out of the way. And you can file a joint petition for judicial notice. You can. But sometimes the other side is like, no, this contract is invalid, right? And they're not asking the court to do that. So there's an opposition to the motion. Okay? All right. You could have maybe a question on real versus documentary evidence. I would take a look at that. That's not really covered in the approach. So take a look at real versus documentary evidence. Take a look at that. Okay,